The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
The case before us is State versus Tyree Jones. Your panel this morning is Judge Tyson. I'm John Tyson. And then we have Judge Hunter Murphy and Judge Toby Hampson. If there are no other matters, we will hear from the appellant.
Good morning. I'm Richard Krautharmel. I go by Rick. I hail from the Wake County Bar. I represent defendant appellant Tyree Jones, and I would like to reserve 5 minutes of my time for rebuttal.
Thank you.
When I got the state's brief in this case, I read it and I researched its cases, and I agreed with the state on a certain issue, which was that the police do have the right to look for somebody they believe may have committed a felony, and they can do so without a warrant. And under North Carolina case law, they can do so for up to at least 48 hours from the cases I've read. And I mistakenly came to the conclusion that the state was right, that my client probably didn't really have a good argument here, so I didn't file a reply brief. And then the court notified me of oral arguments, and I said to myself, okay, what did I miss? And so I started digging a little bit harder and looking at the cases again, and it dawned on me that I hadn't taken a good hard look at something called the collective knowledge doctrine, which basically says that if an officer stops somebody to question them about a crime without a warrant and without having seen any crime him or herself, the stop can still be lawful if another officer who is involved in the investigation did see criminal activity and then conveyed to the stopping officer to stop the suspect. The collective knowledge doctrine is laid out in a case called State v. Battle, B-A-T-T-L-E. It's the site for that is 109 NC App 367 at pages 371 to 372. That's a 1993 North Carolina Court of Appeals case. And what happened in Battle was an officer saw what he believed to be criminal activity. Specifically, he thought he saw some impaired driving, but inexplicably, he did not arrest the suspect or detain the suspect. He left the scene. I believe he told the suspect, "Don't drive a car until I come back or until somebody comes here." But then he also, for some reason, he put a "be on the lookout" over the dispatch radio to be on the lookout for this suspect that he had seen behind the wheel of a car. A short time later, another officer saw the suspect in the car and stopped him and made the arrest. The defendant filed a motion to suppress and said the stopping officer didn't have reasonable articulable suspicion to believe that criminal activity was afoot because all he had was the "be on the lookout." He didn't have any knowledge what he was to be looking out for, and he didn't see me commit a traffic violation. The trial court denied the motion to suppress. The defendant was convicted. It went up to the Court of Appeals, and the Court of Appeals, well, no, I take that. Yeah, no, I got the facts wrong. The trial court actually granted the motion to suppress and said, yeah, you're right. The stopping officer didn't have any knowledge of a crime and didn't know why the first officer wanted the suspect to be stopped. The state appealed, and on appeal, the Court of Appeals reversed and said, no, the collective knowledge doctrine applies here. And what happened was the first officer did see criminal activity, and he conveyed to the second officer to make the stop, and the second stop. So the collective knowledge of the two officers was such that criminal activity had been observed and the stop was lawful. And so that became known as the collective knowledge doctrine. And so what I did was I took a hard look at the evidence in this case, and I had laid much of it out in my opening brief as to what the stopping officer, Deputy Houston, actually knew. And recall, this is a case where a woman OD'd on some drugs. She was the sister of the elected sheriff in the county. The elected sheriff went to the hospital. The woman was saved. She was revived. Supposedly, she conveyed some information to the elected sheriff, and the elected sheriff conveyed the information to Deputy Houston, who actually made the stop of Mr. Jones. And if you look hard at the evidence, what Deputy Houston testified about at the suppression hearing, he says that I knew that Peyton Davis had OD'd. She OD'd on heroin, and she conveyed to the elected sheriff that she had got the heroin from Mr. Jones. There was some question about whether she had purchased it directly from him or through an intermediary, but nonetheless, she said she had gotten it from Mr. Jones. And so that was Deputy Houston's knowledge before he actually went out and stopped Tyree Jones 3 hours later. And what Deputy Houston didn't know was when this alleged distribution of heroin had occurred. And he knew that Peyton Davis had OD'd on heroin and that she had allegedly gotten it from Mr. Jones, and that was all he knew. And he doesn't really convey what the sheriff knew either. He just says, I had a conversation with the sheriff. It was very short. This is all on transcript page 10 and 11 of the motion to suppress hearing. He says the conversation was short. There was the defense counsel went around with him about whether or not Davis had actually purchased the drugs directly from Mr. Jones. And then ultimately, Houston said, I don't know if he got them directly from her, but suppose they came from him in some way. And then later on, the defense counsel asks, well, you don't know exactly when the distribution occurred. And he said, that's correct. He does say prior to her overdose on that particular day, but then he confirms that he did not know that information before he stopped Mr. Jones that day, 3 hours later. And so my assessment is that the collective knowledge doctrine is not met here because we don't know exactly if and when a felony did occur by Mr. Jones. Well,
yes, let me ask you this. Is it relevant that Ms. Davis identified the seller as Nitty and the officers were familiar with the defendant by that street name? Does that add credibility to the person actually being identified by name that the officers knew?
Add credibility to Ms. Davis's tip?
Help give the officers, if they knew an individual who was identified by that street name due to prior knowledge or prior arrest, would that in and of itself give them the basis to further investigate that someone had purchased drugs from Nitty and they knew Nitty to be the defendant?
So I think both the state and I cited this federal case, Sprinkle, that talks about knowledge of the suspect having a prior criminal history standing alone is insufficient to go out and make a stop or a search of the suspect. But I know that there's North Carolina case law that says once you start stacking pieces of information that may by themselves be insufficient, then you can have sufficient information to go out and stop the individual, which always seemed kind of strange to me that, you have one reason standing alone is insufficient, but then when you start stacking a bunch of reasons standing alone would be insufficient, they become sufficient. But I do think if they had other knowledge besides knowing that Nitty had a criminal history, then yes, they might, it would start building towards having that reasonable suspicion to go out and stop and question Nitty about it.
Are you arguing about the time between when the overdose was occurred and when Ms. Davis identified the person who had sold her the drugs or brought the drugs as Nitty? Was Was that more than 48 hours, or is that really in dispute?
My understanding is that it's less than 48 hours. It's like on the order of 3 hours. She goes to the hospital. The sheriff goes and talks to her, directs his officers to go find Nitty, and then they find him about 3.5 hours later. So that's not in dispute. I'm not saying that the time between the overdose and the stop is too long. What I'm saying is that the time she actually acquired the drugs, we don't know. We don't know when she got those drugs. At least Houston didn't know the day he stopped Nitty.
What would be the operative event? Would it be the overdose when she identified him, or would it have been when she purchased the drugs or got acquisition of drugs?
So the felony, if Jones committed a felony, it was in the distribution of heroin. And that's what they don't know. That's what Houston didn't know. He didn't know when that occurred. He just knows that Peyton Davis OD'd on some drugs she supposedly got from Nitty. He doesn't know when she got those drugs. The record does not contain that information either, at least as far as the motion to suppress transcript is concerned. The elected sheriff didn't testify, and Houston didn't exactly say what the sheriff knew. He knew that Peyton Davis had OD'd and that she had allegedly got the drugs from Nitty, and that he was told to go find Nitty.
And that burden, sir, would that be on the state to show with the evidence at the suppression hearing that the collective knowledge doctrine would apply by presenting that evidence that was known by the sheriff?
I believe it would, Your Honor. I don't know that there's any cases on point that say the burden is on the state, but the burden is always on whenever the defendant alleges a constitutional violation, the burden is on the state to prove that the stop was not a constitutional violation. And so I would submit that per State v. Battle and its progeny, that the state has to prove that, no, we had the requisite knowledge to stop the suspect before we actually stopped the suspect. And so,
but so is part of the issue here, though. You know, we sort of in this discussion have been focused kind of on a reasonable suspicion analysis. Did the officer have reasonable suspicion to stop this vehicle? But my recollection of the record is that was not the basis of the trial court's ruling on the motion to suppress. The trial court focused on the community caretaking doctrine based on the notion that perhaps there was a batch of bad drugs and the extent to which the state can essentially put somewhere on put a place basically on lockdown and stop anybody who they might suspect of dealing what may have been a bad batch of drugs. Is my recollection of the record correct on that?
Your Honor, I tend to agree with your assessment of the situation, but I think the state has an argument to make. If you look at page 18 of the record on appeal, the first paragraph numbered 3, there's 2 paragraphs numbered 3 on that page, but the first number 3 reads that reasonable and articulable suspicion of criminal activity existed for the stop of the vehicle to investigate narcotics activity, and then it cites Terry v. Ohio. The next paragraph, which is the first paragraph number 4, then goes into the community caretaking doctrine. It starts discussing that at length. So I agree with you that the court's order is somewhat misleading. It's almost like the community caretaking doctrine is almost like a red herring, in my opinion. The state does have an argument to make that, hey, the judge did cite 2 bases for the stop, the reasonable articulable suspicion and the community caretaking doctrine based on those 2 paragraphs. But I do believe that the trial court still failed, even if it did cite the 2 bases, it still failed in assessing the collective knowledge of what the police knew before Deputy Houston made the stop. And the record is lacking as to what exactly the sheriff knew when he told Deputy Houston, go make the stop. All they knew was Peyton Davis had OD'd and that she had acquired the drugs from Nitty. They don't know when the distribution occurred. If there was a felony, it was Nitty's distribution of the drugs to Peyton Davis. And that is what was lacking. There is a case.
Before we move too far into the community caretaker provision, just because we're looking at that paragraph real quick, and I think we're going to be going down that road. The state argues in their brief at page 7 and 8 that the defendant has abandoned any argument regarding the reasonable articulable suspicion as an adequate independent ground. I know there's not been any additional filings, and there's not been any memorandums of additional authority or anything to suggest that this wouldn't be waived. So I'm trying to put that together, because if that's waived, do we even need to discuss community caretaker doctrine, or is that issue moot?
So, Judge, I would say that I did talk about reasonable articulable suspicion. I didn't do so like overtly and affirmatively, but the title paragraph of my argument says that Houston did not see any traffic violations. And then later on, down on page 24 of my brief, and under the plain error paragraph, my first sentence is, since Deputy Houston had no justification for stopping Mr. Jones's truck. So I do mention this aspect of a lack of reasonable suspicion to believe the criminal activity occurred, but I did not affirmatively go in and state, there were two bases and the trial court lacked justification for both bases for the stop. So, it's somewhat equivocal. My argument, I made the argument that Houston lacked the knowledge of criminal activity to stop her, and that includes a reasonable articulable belief that criminal activity was afoot, as well as covers the community caretaking doctrine.
And one thing on reasonable articulable suspicion of criminal activity being afoot, it's a present tense in the case law, is it not? Have there ever been any past tense cases that are binding on us where criminal activity was afoot in the recent past?
So the case I found was a case called State v. Burdette, Burdette. It's an unpublished case from 2012 with a site of 2012 NCAP Lexus 358 at star 10. And basically they said that the confidential informant's tip was not stale, even though the confidential informant witnessed the defendant with the heroin 48 hours earlier. And so I took that to mean that, the police have the ability to go look for a suspect they believe may have committed a felony up to 48 hours later, and they can do so without a warrant. I also found a federal case that had the same ruling. It's called United States v. Lucky, Lucky, with a site of 569 F 3rd 101. It's from the Second Circuit 2009 case upholding a Terry stop of a vehicle that matched the description of an automobile that 2 days earlier had fled a shooting. And that the law enforcement in that case had not obtained a warrant, but stopped the defendant 2 days later.
Are there any binding cases on that point?
I haven't found a published opinion in North Carolina, either from the North Carolina Court of Appeals or the North Carolina Supreme Court, saying that the police have a period of time after an alleged crime has occurred to go find a suspect without a warrant and stop and question the suspect about the alleged felony. That was what I found.
And I'm sorry, Judge Hampson, I took more time with that, what I thought was a brief question than I meant to. Sorry about that.
And so I would just say that I did argue about reasonable articulable suspicion. I argued that Deputy Houston had none. I did not affirmatively talk about the the collective knowledge doctrine, which I should have. And I would simply say that the record is lacking in what exactly the elected sheriff knew when he told Deputy Houston to go make the stop. Aside from they had known Peyton Davis had OD'd on some heroin that she had allegedly acquired from Mr. Jones, but they don't know when she had acquired it. Regarding the community caretaking doctrine, I do stand by my argument that I made in my brief on that. I believe the court lacked the necessary evidence to make that ruling and find that the community caretaking doctrine had been triggered here. There was no mention whatsoever of a bad batch of drugs, of this being a bad batch of drugs as being the reason that Peyton Davis had OD'd on the drugs. For all anyone knew, she had simply ingested too much of the drug, which you can also overdose by ingesting too much of a drug. So I think it was kind of a red herring to kind of there at the very end to say, okay, by the way, I'm going to go ahead and find the community caretaking doctrine has been invoked here also, and find that the stop was justified based on that.
Now, with community caretaking doctrine, even if there had been a bad batch in the community, would that in itself have been enough reason to stop him, even if we knew that maybe she had made the purchase that morning and taken it that afternoon, and then this is later in the day? Would the allegation of him possessing a bad batch of heroin be enough to stop him under community caretaker, as opposed to taking the step and getting a detached and neutral magistrate to issue a search warrant or an arrest warrant?
My opinion on that is that they would also have to have knowledge that Mr. Jones distributed drug at a particular rate. So they, in order for this to be a threat to the community, and for this to have happened in a single day, say Peyton Davis buys bad drug in the morning, she ODs in the afternoon, goes to the hospital, they figure out, hey, we got a bad batch of drugs on the street. They would have to have some knowledge of how often Mr. Jones distributed drug. So if he's the kind of guy who goes out and makes a lot of sales on a particular day, then yeah, maybe the community caretaking doctrine is triggered and they need to get out there and find him ASAP before he makes more sales and endangers more people. But absent that knowledge, I would say that they would have to go get a warrant and say, okay, well, if this is in fact true, we got time to go get a warrant. We don't know how often he sells drugs. Maybe he does it once a day. Maybe he does it once a week. Let's go get a warrant. Let's go find him and find out. So that would be my take on how to analyze that particular situation.
Well, does community caretaking doctrine require broad potential harm? I can't remember if it was Smathers or Sawyers, whichever one was the kidnapping, or what the officers thought was a kidnapping case. That just involved, community caretaking with one person. So is there any requirement that it be more than one?
Broad, but I think it has to be imminent. There has to be a threat of it occurring again immediately or quickly, or somebody else being in harm's way in the very near future, so as to create an exigent circumstance that requires the police to go look for somebody before going to get a warrant. That's how I would look at that. And in this situation, they had no knowledge of anything, whether the drugs were bad, like i.e. laced with fentanyl or something like that. That was just something that was kind of brought up at the very end by the prosecutor and latched onto by the trial judge, and ultimately wasn't litigated. So it was kind of blindsiding the defendant too, to not give the defendant a chance to address the situation or question witnesses about it. But ultimately there was a lack of evidence to reach the conclusion that the community caretaking doctrine was triggered in this situation. So that also failed as a basis for the stop of Mr. Jones by Deputy Houston.
And if I can ask, I think you may have seen me, I've been looking on the computer a little bit. Did you file any memorandum of additional authority that we may just not have received electronically yet under Rule 28G regarding State versus Battle?
I have not, Judge. I can do that. And again, it's like my mistake was not filing a reply brief. I probably should have. I should have did at the reply brief stage what I did at the notification of oral argument, and done a little more digging on the state's brief and found this collective knowledge doctrine case and briefed it on reply.
Is Battle a published or unpublished decision?
Battle is a published decision, Your Honor.
All right. You cited another case, an unpublished decision. If you intend to rely on that, through a memorandum, you would also need to serve a copy of that on the state as well.
Yes, Your Honor, I can do that Burdett case.
Would it be your contention, sir, that if we decline to consider battle, it would damage your client or be an injustice to your client?
I do, Your Honor. I do believe it would. I think it's key to the case. I think the collective knowledge doctrine is key here as to whether or not the state had a basis to stop Mr. Jones without a warrant. And Burdett actually helps the state's case because it stands for the proposition that the police can go out and look for somebody up to 48 hours without a warrant if they believe that person has committed a felony. So even if you say, okay, we don't know when Nitty committed the felony, but he probably committed it within 48 hours of Peyton Davis ODing, that would help the state's case. So looks like I'm down to under the 5-minute mark. If the court has no further questions, I will hand it over to the state at this point.
Thank you.
All right, thank you. We will reserve your remaining time, about 4 minutes and 39 seconds. Thank you. Okay, at this time, we'll hear from the state.
Good morning, Your Honors. May it please the court, Matt Lyles, Assistant Attorney General on behalf of the state. First of all, let me say I appreciate the reasoned and open and way in which opposing counsel discussed the matters in this case. I appreciate his approach and his fulsomeness on the matter. As you can imagine, since a lot of things that were discussed were not in a brief before us, there's a varying degree of preparedness, but I think the issue here is pretty straightforward. The question is whether there was a reasonable suspicion to support the stop of defendant's car. And if there was, then arguments about the community caretaking provision are somewhat moot. And as we argue in our brief, we believe that there was a reasonable suspicion to stop defendant's car, which soon became a heightened level of suspicion during the stop that led to the drugs that were recovered here. I think the posture of the appeal is very important to its disposition. First of all, as defendant admits, it's a plain error review, the way it was, because at trial, even though the evidence was objected to for chain of custody, even though it was litigated through a motion to suppress, so therefore, it's only proper to overturn the court's decision on if he could show that this was a determinative issue. And that plays into essentially what we were discussing earlier about the sort of two bases for the court's ruling. And I also think it's very important
real quick before Mr. Lyles, before you go on from plain error, under State versus Coleman, a case Judge Dietz wrote a couple of years ago, even if a defendant says it should be plain error review, if we decide it is preserved, we can review for regular error. I'm looking at transcript page 58. I know that there's additional stuff that the defendant lays out in his brief later regarding what was being argued about chain of custody, but looking at 58 lines 18 through 21, why is that objection at this point? Because what all he's objecting to is the traffic stop and what flows from that for the motion to suppress. Why is this objection at 58, 18 through 21 not enough to preserve that error?
He admitted that it was a chain of custody objection. The state took him at his word. And as such, I'm not prepared to argue why it's not a plain error review. I would argue that the whole thing is essentially not determinative because a reasonable suspicion existed regardless. So no matter what standards you look at, there's a reasonable suspicion. And like I said, I think it's very important to look at what was argued in the appellant, the brief. In that on page 18, defendant specifically says he does not challenge the it's the first full paragraph on page 18. Mr. Jones does not challenge the trial court's findings, and the first page and a half of his written order denying the motion to suppress, those are the findings of fact in the order. So when we look about how we review, rulings on a motion to suppress, they're twofold, right? Are the facts in the order supported by the underlying? In his brief, the defendant conceded that those facts. Now, he's argued somewhat differently in oral argument that maybe they don't match. But I would argue to the extent that now they're arguing that the facts don't match the facts that were in the order on the motion to suppress, that he's abandoned those arguments. And when the facts are not in dispute on a motion to suppress, the court takes those as binding and then looks to see if the conclusions of law are supported by the findings of fact in the order. So that's why when I look at this,
doesn't he challenge those findings of fact that we're talking about match and stuff like that later in his argument about community caretaker, or their findings of fact you're suggesting are being argued now that weren't argued at all in the brief? Can you just clarify that for me? I just want to make sure I'm on the same page as you on that.
Yeah, I mean, I think it's very clear on page 18. It says that Mr. Jones does not challenge the trial court's findings in the first page and a half of its written order, which are the findings of fact. Those findings, by and large, reflect Deputy Houston's testimony at motion to suppress hearing. Mr. Jones challenges the findings and conclusions of law under the heading ruling, which begins on page 17.
Let me ask you.
Okay, I've got you. Thank you, Mr. Lyles.
Mr. Lyles, let me ask you a question about the collective knowledge or whatever. When I look at Judge Pate's order on page 16 and 17 of the record and the findings of fact, it appears that the sheriff's sister told him that she had gotten the heroin from Nitty. And the sheriff knew Nitty himself, or knew that Nitty was supposedly the defendant. That's finding of facts 5, 6, and 7. And then the sheriff communicated that knowledge to Houston. So that was a direct transfer, was it not, of what the sister had told the sheriff from the sheriff to the major, who also knew Nitty, correct?
Yes, Your Honor. That's how I read the facts, and that's how I read the order, and that's what we argue. The collective knowledge doctrine, I haven't seen State v. Battle, but generally I understand is that the police are judged on an objective standard based on the totality of what they know. So in this case, when you start, as counsel said, stacking up the bits that lead to a reasonable suspicion, which is important to know, is a level that's below probable cause.
But is this different than a BOLO, a be on the lookout, which, those orders are put out, that would be more collective knowledge in a BOLO order, as opposed to a direct communication from the victim to her brother, who was the sheriff, and then the sheriff having independent knowledge of Nitty and communicating that to the major. Is that a different situation than a collective knowledge? Isn't that more direct knowledge?
I believe that's a reasonable way of putting it. I mean, if you look at the collective knowledge requirement in general, I believe it's to help police to say that in order to effectuate a stop, the investigating officer does not have to convey to the stopping officer every single bit of information reaching that suspicion in real time.
What about the BOLO orders? We see on the highways sometimes a kidnapping or a public alert that a certain car with a certain tag is wanted for something like kidnapping or whatever. I mean, even the DOT communicates that to the public. Now, so, I mean, is that collective knowledge? Or I'm trying to differentiate. If there's reasonable suspicion for a BOLO, be on the lookout. And I think there's precedent to support that. Isn't this beyond that because the knowledge was passed directly from the victim to her brother and from her brother directly to the major?
Yes, Your Honor, I do believe there's more amounting to a reasonable suspicion than just simply a be on the lookout for nitty. It is the sheriff who knew the defendant, who got this information directly from a victim of what happened, relaying the events directly to the officer, who also, through his narcotics experience, was familiar. That's in the findings of fact as well with the defendant. When you combine all those together, that's more than just a be on the lookout. That's a be on the lookout, and here's why we're on the lookout for him. And based on my previous knowledge, which as the Sprinkle case was cited, says it can be a factor. It can't be determinative. You know, you don't want to target people merely because I can stop someone because they're a known drug dealer. It has to be, you stack on, because when you look at it, there's a reason the reasonable suspicion standard is the totality of the circumstances. And if you look at the North Carolina Supreme Court has said that a warrantless stop is reasonable when it must be based on specific and articulable facts, as well as the rational inferences from those facts, as viewed through the eyes of a reasonable, cautious officer guided by his experience and training. That's State v. Watkins, cited in a brief 337 NC. You know, a reasonable suspicion has to be something more than a hunch. In State v. Brown, this court said all the state must show is at a minimal level of objective justification, something more than an unparticularized suspicion or hunch. They had more than an unparticularized hunch here. They had a tip, and in the order, the court goes into why Judge Pate found that tip persuasive. In her ruling, I believe it's her second number 4 on page 8. She notes that it was given by a person rather than anonymously. She didn't say anonymously, but obviously reasonable suspicion can be based on anonymous tips. But there's case law that shows that a tip from a known informant given face-to-face is given more veracity, and that she had a motivation to be truthful and honest to her brother. I mean, there's a reason for that. You know, there's case law. It's the Allison case, which is 148 NC APP 702, notes that by directly engaging a law enforcement when giving a tip significantly increases the likelihood of accountability if there's a false tip. So you stack that all on top of just the sort of be on the lookout, and there's a reasonable suspicion to talk to the defendant here.
Well, isn't there a reasonable articulable suspicion that a crime at some point was afoot? There wasn't, if I'm remembering the facts correctly, nothing tying it to the vehicle. The vehicle information comes from Houston's knowledge. Nothing tying her purchasing the drugs to the vehicle, and nothing tying her overdose to anything in time regarding when this purchase took place. So I guess I'm having trouble figuring out how there's reasonable articulable suspicion that a crime is afoot as opposed to was afoot.
So to that bit, I would say that goes to the sort of the rational inferences piece of the reasonable suspicion. You know, I think there's some discussion in the argument before the court about how, you know, typically someone taking drugs, they don't obtain it and then wait hours and hours and hours before they consume it. It's more of an immediate thing. You know, I think there's a very reasonable conclusion to draw that that had happened with a close temporal time. And when you start looking at other things, that whether the crime was ongoing or had stopped, it becomes really hard to parse, because we have a number of times in which there's been a reasonable suspicion to stop, say, a car in a high crime area or a car after a robbery has occurred. The robbery is over. Of course, now there may be some additional crime for fleeing the scene.
Well, you still have possession of stolen goods in that case, or
right.
With a kidnapping announcement, you've got the possibility the child's still in the car or the person's still in the car.
Right, right.
So there's still something afoot, not something happened in this vehicle we don't know when in the past, which is going back the whole point of why we have magistrates for these things that happen outside of the officer's presence. Just no crime was committed in the presence of the officers, which would, give an exception. But, here, I just don't see anything from the findings of fact or even reasonable inferences that there's close enough in time and tying it to the vehicle as where this happened and where the drugs are kept or drugs are dispersed, and maybe I'm missing something there. So if I am, I'd really like you to show me kind of directly in the findings of fact. I know we have 3 hours after the information is conveyed, but I'm thinking if somebody, a teenager goes to the hospital because they drank too much alcohol and they say, "Hey, who gave this to you?" And they say, "Joe Smith that I work with." If you just have that, you have no idea if this happened 8-9 months ago. Is there something different about heroin possession and heroin usage that would take it out of the realm of making this a more recent transaction that maybe we can infer here? I just don't see anything here that would do that. And there's nothing about her economic status, her usage tendencies, anything like that would say, yeah, she gets it, she uses it that day, and the sheriff knew that, and that got passed on. She's a big buyer, and she parses it out over a year. It just seems like a lot of questions there that weren't resolved in the evidence presented by the state.
I think that goes back, Your Honor, to what I previously said about the general tendencies of drug users not being to hold on to things for a long time. You certainly could infer that. Given the ambiguity, I can't point to some temporal element that's not there. The question is how do you resolve it within the bounds of the appeal? I believe there's case law that says when you're looking at the facts underlying a case and there's an ambiguity, that the appellate courts will defer to the trial court judge who was closer to the situation, especially here when the findings of fact were not at least originally in question.
I'm looking at paragraph 8, which the defendant's already stipulated to. The last sentence of that says on page 17, Major Houston knew the type of vehicle frequently operated by the defendant was a golden colored GMC pickup truck. And that's exactly what he was driving when he was stopped. So isn't that part knowledge? Is that part of the additional piece of knowledge that Houston would have known when he saw that truck the defendant was probably driving?
Your Honor, when you combine that with the fact that someone, the sheriff himself who knew defendant on site positively identify him, I definitely think that stacks into saying there's a reasonable suspicion to stop the car. Now, it's important to note that what you have to weigh here is the Supreme Court has said the fourth. I guess I could be better if I can read it. They can write better than I can speak. The Fourth Amendment does not require a policeman who lacks a precise level of information necessary for probable cause to arrest to simply shrug his shoulders and allow a crime to occur or a criminal to escape. On the contrary, Terry recognizes that it may be essential, the essence of good police work, to adopt an intermediate response. I would argue that in this case, giving the sort of stacking factors of being relayed by a known person who had the rules of evidence give people who are hospitalized the statements they make an increased level of veracity, to her brother, to someone who's known by police for drug activity. I give that a reasonable and particularized. When you look at about other stops, there's North Carolina case law about a taxi cab driver who just said the plate number and they were driving recklessly. That's a lot more sparse and sort of scattershot than I received. As Ms. Davis was witnessed, or I guess even took part in a crime by this individual at this time. So the alternative would be you have all that information and the police are supposed to let him drive by. Then additional suspicion is obtained when Major Houston turned on his blue lights and he continued for 2.5 to 3 miles. There's case law to say that what happens when they encounter police can arise additional reasonable suspicion. And it's I think it's extremely important to the administration here that the reasonable suspicion to investigate narcotics activity, which the court in ruling paragraph 1 and ruling paragraph 3 specifically rules was there. And in the hearing itself on page 27 echoes that, that there was no argument made in the first brief to challenge that. They said there was no traffic violation. They said the community caretaking doctrine didn't apply. But under Rule 28b-6, issues not presented in a party's brief or in support of which no reason or argument is stated will be taken as abandoned. There were no cases cited. We have these new cases about why reasonable suspicion doesn't apply. I would argue that argument has been abandoned. And you know, for that reason, I think the reasonable suspicion blocks stacked on top of each other. I think you get very close to requiring something to the level of probable cause. The more granular you get, for reasons in the brief, I believe there could be a community caretaking function, but I don't think you have to get to that here because of the reasonable suspicion. But I'm happy to talk more about the community caretaking provision. But I do believe.
Mr. Lyles, if I can jump in, so I think part of what I'm struggling with in this case is that there's sort of a disconnect between the findings of fact and the conclusions of law, which really I would sort of characterize more as a combination of conclusions of law and really sort of ultimate findings of fact. You know, it sort of strikes me that had the trial court taken these findings of fact and said, based on this, Major Houston had reasonable articulable suspicion that defendant had been engaged in illicit dealing of drugs, had sufficient information to stop him. That's one case. But my read of the trial court's conclusions of law, even conclusion 3, which is reasonable and articulable suspicion of criminal activity, it strikes me if you read it, the conclusions of law in context, along with those sort of ultimate facts, the trial court's basing that conclusion on the existence of the community caretaking doctrine arising from this concern that there's a bad batch of drugs. And so to me, there's sort of a disconnect there. And, you know, setting aside as to whether we could sort of modify and affirm, find that there was this alternative basis, if the trial court had simply found straight up reasonable articulable suspicion of illegal drug dealing, separate and apart from community caretaking. It just strikes me that the trial court conclusions of law seem to suggest that that's all intertwined. And you can imagine why in a case like this. It's a sensitive case that, you know, if there's a different narrative between, you know, the sheriff having a basis to believe that there's a bad batch of drugs in the community versus, you know, sheriff's sister having such an opioid problem that she took too much and overdosed. I mean, those are two sort of competing narratives. And so I guess I'm not sure what the question is there. I'm just trying to articulate what I'm struggling with. And perhaps the question is, you know, can we sort of rewrite those conclusions of law based on just a straight up reasonable articulable suspicion type analysis of just the drug dealing and the identification of Nitty, the defendant being the dealer here.
Thank you, Your Honor. I mean, I think I appreciate you hitting on a confusion that I think we all hold, and I appreciate you talking about the sensitivity of the matter to that piece. I think the case law is pretty clear that when we look at reasonable suspicion, we look at the objective reasons for stopping, not the subjective reasons. You know, if an objective reasonable suspicion exists, then the subjective falls away, you know. And so I think that piece, well, I definitely think it's a concern. I don't think it factors into the illegal analysis. Insofar as the order itself, I think it's very important on that confusion to separate that community caretaking and reasonable suspicion are two very different things. If you have a reasonable suspicion, you do not need the community caretaking doctrine. If you look at the Smathers decision, there was not a reasonable suspicion to stop the person who had hit an animal. They said, because you don't have this, you need the community caretaking provision. It's not binding, but it's persuasive. If you even look about the Superior Court judge's bench book, they named them as different doctrines for a warrantless search. And the same thing with the Sawyer case. Although that's much more like one here where you would argue they had both a reasonable suspicion, the court found a reasonable suspicion, essentially said we don't have to go any further, but there was a caretaking reason. And all that coming together, when you look at the order, that means if you look at the two places, paragraph 1 and paragraph 3, where the judge says there is a reasonable articulable suspicion, to say that depends on a community caretaking doctrine, it essentially reads the reasonable suspicion part as non-existent, which would, I think, be against kind of the canon of how you interpret orders. As mentioned, there isn't anything in the findings of fact about the batch itself. And so to say that the reasonable suspicion was based on a fact that's not in the order itself, I think belies the plain reading of the order itself.
If this information had gone out on a BOLO, and let's say it was a state patrolman, someone wholly unrelated to the sheriff, had received this information as a BOLO, be on the lookout for a gold GMC pickup driven by Jones. If that had been on a BOLO, would a state patrolman have had reasonable suspicion to pull him over on a BOLO?
I think it would be a much closer case than this, because you would also have to add the fact of, was the patrolman aware, did they know the defendant? Did they know the defendant's past drug activities? When they turned on the lights, did they go another 2.5 to 3 miles down the road?
The findings said the major recognized him before he even got up there, and then the window was down and he smelled marijuana. That would give him probable cause at that point, would it not?
I believe it does, Your Honor, and I think rightfully defendant would agree that he doesn't challenge what happens after the stop. It's merely a reason for the stop. Once he gets up there, you have that. You see the drugs on his lap, with what looks like from the officer's experience to be a substance on his lap. When he gets out, he stands up. Another bag falls out. I think you have probable cause plus there on that point. If the court doesn't have any further questions,
I have a couple for you, Mr. Wiles.
Go ahead.
First, I want to circle back to plain error versus regular error, and we don't need to get into the preservation and the transcript for this question. But with plain error, have our courts basically ended up at a de facto rule that if it's a motion to suppress, it's going to be plain error if there is error on one of these possession cases when it's just about what's found as a result? Can you point me to any case, published or unpublished, where we said not plain error when there was error on the motion to suppress?
That's a really good research question. I'm probably going to go do it afterwards, Your Honor, but I can't point you to that right now. I'm sorry, but
that's okay. And then, and this is maybe a statement and it may be a question. With the bad batch, say somebody, and this is just hypothetical, say there's 3 cases in the hospital of heroin users that have gotten a bad batch. It's not just using too much, it's something tainted in the local heroin supply. They can't testify where it comes from. Under the community caretaker doctrine, if we said a bed batch was enough in this case, could that expand, or could this case be used to say, hey, you can go up and stop anyone that's been a heroin dealer and usually is involved in the heroin trade, to investigate this community caretaker doctrine, go in their house, go into their car, stop them on the side of the road. Where's the line? Even if there's a bad batch and bad things are happening, I mean, that's the criminal justice system. That's what it's here for. I mean, there's crimes being committed all the time, but that doesn't justify, a warrantless search or stop. So I guess I worry if we say bad batch in this case is enough. Where's the line?
Mindful of my time, Your Honor, I think you had a concern we're all concerned about, and I think that's why the community caretaking provision has a balancing act, balancing the public need versus the intrusion upon the individual's privacy and the reasonableness of the suspicion. I don't want to use suspicion, but the reasonable basis for the caretaking function. I don't think it's scattershot. That the courts have said it needs to be construed narrowly, but it's been used in cases for, originally it came from disabled vehicles on the street posing a hazard. Originally it dealt with, when you've hit an animal. I would argue that it's the heroin epidemic presents a significant public health reason, and where that balancing works out in one way versus another, I can't draw the line right now, but I don't think we could say it wholly could never be a basis for the.
I'll give you a moment to sum up, sir.
Judge Tyson, can I ask one more procedural question real quick?
Yes, of course.
If we were to use Rule 2 in accordance with Citizens Addressing Reassignment Education versus Wake County Board of Education, 182 NCAP 241, to consider the arguments raised at oral argument that were not previously briefed or part of a memorandum of additional authority. If we invoked Rule 2, would the state want an opportunity to file a supplemental brief regarding Battle or these other cases brought up for the first time at oral argument?
Yes, Your Honor, I believe it's only fair for that to happen that way. And as for the foregoing reasons, in addition to those in our brief, we respectfully request that the court deny defendant's appeal on all counts and affirm this conviction below. Thank you.
Thank you.
Thank you, Mr. Lyles. Rebuttal from the defendant?
Yes, Your Honor. First, I want to address the actions after Deputy Houston's blue lights came on. I would assert they're irrelevant. The Fourth Amendment of violation here occurred when Deputy Houston activated his blue lights. That's when he was effecting a seizure of the defendant. And the Fourth Amendment covers searches and seizures. So whatever happened after those blue lights came on is the fruit of a poisonous tree. Regarding Judge Murphy's question about preservation, my understanding is the defendant has to object to the admission of the evidence when the state offers the drugs into evidence at trial. That's when the defendant has to object in order to preserve his motion to suppress, because his motion to suppress is based on suppressing those drugs. So the objection at page 58 was to the stop of the defendant. And I'm not sure why the defense counsel made that objection. The other thing in this case was the defense counsel spent a lot of time arguing the chain of custody, and I felt like a majority of his objections were based on that. Regarding Judge Tyson's question about...
Mr. Cremont, if you'll hold on 1 second, we lost Judge Tyson's feed. So if you'll wait just a minute before going into your next part. And okay. I note you had about 3 minutes and 30 seconds left at that point. So we'll let Judge Tyson know what time you had on there when he gets back on, if you'll just kind of bear with us for a few minutes.
Okay. I don't know what happened to my feed. Are you hearing me?
I can hear you now. We can't see you. He had about 3 minutes and 30 seconds left when we lost you, and I stopped him, John.
Okay, I'm going to start the video again. Is that better?
We can see you again. Yes, sir.
Okay, go ahead.
So my next point concerned Judge Tyson's questions and comments about, wasn't it enough that the police had knowledge of an overdose? It was an overdose on heroin. They knew the person was nitty, and they knew what kind of truck he drove or what the identification of his car, I would just point the court to a case called Florida v. JL, the initials JL. The site is 529 US 266. It's a 2000 United States Supreme Court case that stands for the proposition that the reasonable suspicion at issue requires that a tip be reliable in its assertion of an illegality, not just in its tendency to identify a determinate person. So it's not enough just to identify somebody. You have to also say what the illegality was that occurred. And I do believe that the sheriff's sister alleged an illegality here. We just don't know when it occurred. She alleged that she had obtained heroin from a person called Nitty. That suggests a crime called distribution of an illegal substance called heroin, which is a felony, but we don't know when it occurred.
Yes, if someone's kidnapped and escaped, it takes them 3 hours or even a day to get to law enforcement, and then they report the crime. Or a sexual assault that is reported 3 months later. Don't the officers have a right to act on that? Not more when it's reported and not necessarily when it occurred.
The officers have a right to go find the suspect and stop him and question him about it within a reasonable time. Like if you're talking about the kidnapping, a woman, say she gets kidnapped, she escapes 3 months later, she goes to the police, she says, this guy kidnapped me. The police have a right to go find that guy and question him about the kidnapping without a warrant. Now, if you're talking about like an imminent type thing where like a drug distribution and you're talking about a matter of minutes or days, I believe there comes a point where the information becomes stale. And that's where you have to look at those cases that discuss staleness to see when the tipster's information becomes stale.
I guess what I'm saying is the date when the sister acquired it even relevant when it goes to more of when the crime was reported. There's no statute of limitations on the crime, and officers cannot act on something until it's reported by someone.
Right.
So I guess that's my question.
I think we're still in the range of a tip. And if you look at this, both officers, both the elected sheriff and Deputy Houston, did not actually see any illegality. They were going based solely on a tip from a known source, the elected sheriff's sister, who said, I got illegal drugs from Nitty, but she doesn't say when. So if you think about it, anytime anybody comes to the police and says, hey, I got illegal drugs from somebody, can the police immediately just go out and find that person? Or should they have a little bit more information about when the distribution occurred, and then they'd be required to go get a warrant if it occurred sometime in the past?
I think the evidence, at least the findings of fact from Judge Pate, showed that they had prior knowledge that he went by that street name and that he sold drugs. Both of them did, both the sheriff and Major Houston both. Is that correct?
That's correct, Judge, but I would assert that just identifies a person. It doesn't identify an illegality that occurred, a specific illegality that occurred like within the recent past that allows the police to go look for somebody without a warrant. And then I would also point out that on page 18 of my brief, I did assert that I challenge all of the paragraphs after the subheading ruling, and that includes that first paragraph 3 where Judge Pate talks about the reasonable articulable suspicion. So even though I did not affirmatively say, okay, there's 2 bases here, I'm challenging both bases, I did challenge all of the findings / conclusions that came after that ruling heading. And then lastly, I just wanted to say that I think it's probably one good resolution of this is to say, hey, parties, we need further briefing. I've had the Supreme Court do that in my cases where they identified an issue that the parties had not identified and they wanted to hear on it. So they told the parties, we want to hear further briefing on this particular issue. And then the parties submit further briefs on the issue. So I think that would be an appropriate resolution in this case, if the court so desired. But otherwise, I would ask the court to rule in favor of my client and find that he suffered a Fourth Amendment violation and that it was plain error. Thank you.
Thank you, sir. Any other questions by the court?
No, sir.
Okay, all right. Well, the case is submitted. We thank the parties for the good arguments, and we appreciate it. And Mr. Clerk, at this time, we will recess court for the next argument.
The court will be in recess.
Okay,
And Your Honor, you still have to sign out and.
yeah, I was going to try to ask the other two judges what they want to do. They got off pretty quick, didn't they?